thing that the court was given at this stage was the dates of the alleged mentioning of the name, but the incidents where she was approached, I don't have any information. She is fearful to go to the mall based on what incident that happened, when, where, on what date, and who was the perpetrator on the date in question, and what are the reasonable steps taken to try and ensure that safety is concerned. Can it then be an inference that could be reasonably be drawn by the court or any other person? And should an inference be drawn, is that an inference going to be the only inference that any other person in the capacity either of the court or any reasonable person drawing such inference, can they then safely say that where a name Miss Malaza or Mrs. Malaza is mentioned, it automatically refers to this particular witness? Is the said Mrs. Malaza the only Mrs. Malaza that has ever existed? And is it necessarily because she has to be associated with applicant number one because of this present case, or because of the case against her? According to the defense, the submissions are that the accused person is a complainant in a case relating to the burning of the church. The court would have understood it differently if it were to say that she feels threatened because he, on the podcast, discussed details of this particular matter or any of the issues that are related to this matter. As a result, therefore, she feels fearful or threatened. The mentioning of the firearms, is it a fact that became only known to her from the podcast, or is it an issue that existed prior? During the bail application, was it an issue that was discussed? Is it that he could be in possession of licenses in respect of those firearms? Those are some of the things that, when weighing up this particular issue, the court would have to look into in order to draw an inference. And as I have already indicated, there cannot exist more than one inference to be drawn on the basis of the set of facts. Only one inference must exist at the end of the day. If it pertains to Mrs. Malaza, could an inference be drawn that when the accused is speaking about Ms. Malaza on the podcast, automatically it relates to her? There could possibly be another Ms. Malaza other than the one that is mentioned. Unfortunately, at this particular stage, particularly on count number 2, I can't make out the surname. Maybe the state may be able to assist me. There is Megima Musileng Ntsiye. I don't know whether this is Ntsiye. I can't make out the handwriting properly. Please assist on count 2.
Meke Mamuseleng. Webster. It's a Webster.
No, the one underneath.
Meke Mamuseleng Webster.
There is Webster on top. There is another one on count 2. There is another Meke Mamuseleng, but the other it cannot read Webster. The handwriting cannot be Webster.
It's Webster.
Threatening?
Yes, threatening to injure the said Maggie Mamuseleng Webster. Thank you.
What is also not clear to the court at this instance is whether the said witness becomes Malaza by virtue of marriage or by virtue of her being born in the household of Malaza, which therefore culminates to the fact that it becomes difficult for one to can be able to safely draw an inference that will relate. Is a matter of state versus Nzuza. Although it was not a high court type of a decision, it was a regional court decision in Durban, where the court was dealing with almost a similar set of facts, even though it is not a precedent at this instance. The court in that matter indicated that for Section 63(1) applications to be done, conditions or circumstances must have changed that will render the necessity to have the bail conditions amended. So under the circumstances, after having listened to the state and the submissions and the incorrect assumption that the matter is brought under Section 64C, I am not convinced that at this stage the court should temper or interfere with the conditions as previously placed by the court, because the inference to be drawn can be more than one inference, that it could be another Mrs. Malaza that burned down the church, as long as there was no mention of either the name or the initial or anything that will bear specific reference to the said person who is a witness in the matter. I am satisfied that there are no violations of the bail conditions at this stage, since it was only indicated that he should not directly contact or indirectly contact the witnesses, and not to say that he should not say anything or mention anything. And should he be doing so, it could as well be that he is expressing his views as a complainant in the matter where he had opened a case, and it cannot safely be that he intended, his intention was to try and endanger the safety of the witness in this particular matter, because no reference, according to the state, was made to this matter. Reference was made to the incident of the burning of the church, which is a matter that is not before this court. This court cannot amend bail conditions based on a matter that is happening in another court, and which the court has no facts of and cannot be able to comment under the circumstances. So I am of the view that the bail conditions, as indicated, they are sufficient enough to provide protection to the witnesses. Should there be a violation of the bail conditions, the state is fully aware that Section 68 will have to be applied, and his bail will have to be cancelled upon an application brought by the state. But at this stage, I don't have sufficient information that would lead me to draw the only reasonable conclusion to be that by mentioning Mrs. Malaza, then it meant indirect harm to the said witness. That by mentioning the issue of him owning firearms, it automatically means that he wants to harm her, or the intention was to try and harm the witness. I am of the view that based on the facts as presented before me, a conclusion cannot be drawn that the mentioning of the name or the firearm was intended to interfere or to influence or to endanger the safety of the said complainant. And as such, I will not grant the application by the state to amend the bail conditions at this stage.
Court pleases.
The court pleases.
Investigation, the worship is complete. Request the matter to be